Good morning, good afternoon, and good evening to you all, depending on where in the world you're joining us from. My name is David Wellman, and as the director of the Gray School of Applied Diplomacy at DePaul University, it's my pleasure and privilege to welcome you to the third and final day of our conference, Environmental Diplomacy, Exploring Trans-Professional Contributions to Global Survival. Today, we will begin with a keynote by Teresa Fajardo entitled Facing Ecological Challenges, the Future of Environmental Law. This will be followed by two panels. The first is entitled Indigenous Voices of Global Environmental Diplomacy, which will begin at the top of the next hour, where we will hear from both First Nation and Native American perspectives on our topic. And our final panel of the conference is entitled Interconvictional Bridge Building as a Diplomatic Response to the Ecological Crisis. And on this panel, we will get Jewish, Christian, and Muslim perspectives from both France and the United Kingdom on the practice of interconvictional bridge building, which is inclusive of interfaith and agnostics and atheists. And so it's going to be a great panel, and I hope you'll be able to stay for all three. This morning, it is my great pleasure to introduce Teresa Fajardo, who is an associate professor of international law and international relations at the University of Granada, Spain, where she teaches public international law at the Faculty of Law and international and European environmental law at the Faculty of Science. Her research examines international and European environmental law, EU migration policy, international law of the sea and soft law, and environmental crime. She has worked for the legal service of the European Commission and has been a visiting researcher at the University of Brussels, the University of Geneva, Cambridge University, King's College London, and the University of Oslo. Her publications include the co-edited volume with Mark Campan Erika, Biological Diversity and International Law, Challenges for the Post-2020 Scenario, published this year by Springer Press, and La Diplomacia del Clima de la Unión Europea, la acción exterior sobre cambio climático y el Pacto Verde Mundial, published by Rus also this year in 2021. Teresa has been very productive. So I'm very, very happy to welcome Teresa, who joins us today from Granada, Spain. Welcome to you, Teresa.
Thank you very much, David. I would like to start with words of gratitude for David Wellman, the DePaul University, and the Gray School of Applied Diplomacy, and the organizers for their invitation to participate in this seminar. I always prepare my presentations bearing in mind the audience, because I imagine it as an experience of thinking together, of walking together, a path of sharing knowledge and experiences, but leaving room for discovery. Thus, I thought that today I was going to have the privilege of talking to and thinking with the diplomats of the future and the diplomats of every day. In the sense of the studies of the Gray School of Applied Diplomacy, diplomats that will represent the interests of the countries, but as well the interests of multinational companies, customers, farmers, NGOs, taking into account and at heart the interests of the planet. And it came to my mind the words of some of the United Nations civil servants saying that the United Nations is the natural habitat for diplomats, especially when they have to address global warming, biodiversity loss, all these ecological challenges that I'm going to talk about this morning with you. I do believe that the ecological challenges should be addressed in the multilateralism forum that is the United Nations. And I thought this is the formula and the forum where the voices should be heard. Even though that we are now experiencing this crisis in which we are hearing more and more voices for unilateral positions and that are somehow undermining the multilateralism and the United Nations approaches. Thus, my task today is to talk to you about the ecological challenges and the future of environmental law, but what I'm going to do is to propose you some sort of trip back to the past in order to face the future. So I would like to see the PowerPoint now, and I'm going to ask Reina and David to be moving in this PowerPoint. So now if we go to the next slide, you can see that I am referring to the Stockholm Declaration. Almost 50 years ago, the first United Nations Conference in the Human Environment, celebrated in Stockholm, 1972, adopted this declaration on the human environment. In the preamble of this declaration, we can find a diagnosis of the planet. And this diagnosis is still fully valid today. 2 decades later, the Brundtland Report on Our Common Future, and then a little bit later, the Rio Declaration adopted in the United Nations Conference on the Environment and Development in 1992. They repeated the same sort of diagnosis. Please pass the slide. But for me, it's very important just to remember what was said in the Stockholm Declaration, because this is maybe a reminder, not a kind reminder of our past and of the things that we should take into account and to remember. It was said in this occasion that a point has been made, a point has been reached in history when we are becoming aware of the consequences of our acts. And this is something that for me is definitely something that we should take into account today. So the diagnosis was carried out once again, and even more if you remember the different conferences that have taken place in the last decades. I was thinking about Johannesburg in 2002, in Rio de Janeiro 2012. The situation is always the same. We are not taking into account the impact of our actions in the environment. So if we think about the main problems that our planet are suffering, we should say poverty. And poverty is forcing developing countries to exploit their natural resources in a way that is totally unsustainable, but they are forced to do so in order to reach the level of development that they are expecting. And on the other hand, the other problem is our patterns of consumption and production in the developed countries. So we have put the planet in a situation that we should reconsider the way we are producing and consuming in this planet, because maybe we are facing a turning point in our history as humanity that we should consider other ways of acting. In this Stockholm Declaration, if you can read the slide, you will see that the insight that was made in that moment, for me, is very clarifying. They say, through ignorance or indifference, we can do massive and irreversible harm to the earthly environment on which our life and well-being depend. Conversely, through full knowledge and wiser action, we can achieve for ourselves and our posterity a better life in an environment more in keeping with human needs and hopes. So in that moment, for me, and this is why I talk about a diagnosis, that the patient, the planet, is now in a critical state due to this rising temperatures, the chemical pollution that affect all living beings on the planet, not just humans. And this is something that I would like to mention at least. It's just in the diplomacy, in the negotiations at the United Nations level, in all the conference of the parties, of the different environmental agreements, there is always a vision that take humans as the center of our analysis. This anthropocentric approach that we have used all the time is maybe one of the reasons why we have forgotten how important is to take into account the value of the planet, the value of the species of flora and fauna, and to introduce this environmental approach or this biological approach in order to assess what are the problems and what are the possible solutions. So for me, there is something very important to take into account as well. It's just when we have made a diagnosis of the patient of the planet, it is something that for me is important to remark is the fact that we can find the solutions in the Stockholm Declaration and in its preamble. So the solutions have been there all the time. It happens the same thing with the Brundtland report, Our Common Future, and it happens the same in the same way with the Rio Declaration. The problems and the solutions are there. So why the patient is still in such a critical condition? And this is something that I would like to discuss with you as well. So the Stockholm Declaration says that the first solution is that we take responsibility for our acts. And this is now when I ask you to pass the slide, please. So it says, and this is something important, that just quoting, to achieve the environmental goal of protection, the states demand the acceptance of responsibility by citizens and communities and by enterprises and institutions at every level, all sharing equitably in common efforts, individuals in all walks of life, as well as organizations in many fields, by their values and the sum of their actions will shape the whole environment of the future. However, it was clearly said, and please, can you pass the slide? It was clearly said that local and national governments will bear the greatest burden for large-scale environmental policy and action within their jurisdictions. And I will add, within their area of control, because this is something that was reflected in Principle 21 of the declaration that was reintroduced with slight changes in the Principle 2 of the Rio Declaration. And saying so, it's very, very clear that the way to act that was expected in that moment was that the states of the world would adopt measures to protect the environment, accepting a limitation in their sovereignty that consisted basically in the introduction in their legal system, in the national regimes, measures of different legal intensity, developing policies, introducing binding instruments to protect the environment. So they gave the states a mandate to adopt environmental law at the national level. And maybe this is one of the points that for me are more clarifying, that for me is also important. There is something very, very important. From that moment on, it was clear that there should be some sort of asymmetrical approach to the acceptance of obligations and to the implementation of the different international environmental agreements and the national legislation that should be adopted in order to transpose these international environmental agreements. However, the main problem and things have not changed, is the lack of resources. And this is something that we can use as well to make an assessment about the governance, the international green governance. If we think about what has happened in this past 50 years, we can see that after the Stockholm Conference, the General Assembly of the United Nations adopted several resolutions in order to create the United Nations Environment Program. It was invested with a very ambitious mandate. However, the situation is that the UNEP could not develop all the different goals and the ambitions because of the lack of resources. And this is something that has not changed. The European Union, and I'm going to introduce this role that the European Union has played from a long period of time, started to have different administrative agreements with the UNEP in 1972, making a commitment with funding UNEP. And this is some of the things that has been a constant in the EU relationship with UNEP. However, the European Union tried to promote the idea that there should be an international organization dedicated to the protection of the environment. And for that, the European Union thought that the UNEP should be upgraded to an international organization and not just to be a program of the United Nations. So I could say that the European Union diplomacy regarding this idea of enforcing or enhancing the possibilities of acting for the UNEP failed, because the European Union could not get the support at the international negotiations conferences where this subject was treated, first in the Johannesburg 2002, then in the pre-conferences that led to Rio 2012. And it's one of the things that the European Union has to consider as a failure in its global green diplomacy. So we should say as well that the reason why the UNEP has not been promoted to an international organization is also because states don't want an international organization that could limit their sovereignty in this particular sector. The environmental protection is a sector that will lead to limits in the way they exercise their territorial competence, the way they designed environmental policies or policies related with the exploitation of their national resources. And this is not just the problem. The problem is that from that moment on, in 1972, we knew that developing countries needed the resources in order to protect their environment. At the same time, they were saying very clearly that they wanted to exercise their sovereignty right without interferences, because they were asking for their natural resources. They were asking, in that moment, we have to keep in mind that we are talking about the last period of the decolonization at global level. So it was a moment in which the different positions of the developing countries and developed countries were quite important. So what is the main problem? And I would like to reach to that point in which we can ask this question: why the patient is not getting any better? And so I would like you to pass to some of the slides. So why the patient is not getting any better? Why the planet is not feeling any better? Because of this. Usually we think about the lack of will of states to assume compromises. For me, is as well something very important. And I was going to give you a possible answer trying to provoke you, at least from the point of view of an academic, but as well, we will try to use formulas in which diplomats are involved. So why environmental law, or why environmental agreements in the different sectors in order to protect biodiversity, to fight against climate change? Why this environmental law, or why these environmental agreements are not working? Are they fit for the purpose of meeting the ecological challenges? And my answer is no. And the reason why my answer is no is related with the lack of enforcement, with the lack of implementation and compliance with the main goals of these environmental agreements, or the national legislation that have been adopted in order to transpose and to reach the main goals of these agreements. So if you pass the slide, please. At the same time, I wanted just to tell you about some of these ecological challenges, because these ecological challenges, climate change, biodiversity loss, the different sorts of pollution, they share many underlying drivers of change. And at the same time, if we think about this year, this is a special year because all the important conference of the parties of the different environmental agreements, they are resuming, they are taking place. In fact, this week, the first part of the Kunming conference on the biodiversity was closed, the last Wednesday. And this is very important because it's the first time that diplomats are gathering together. And even though it's some sort of a test for the next big meetings and the big conference of the parties. So in the case of the Kunming Declaration that I will show you later, what are some of the main ideas, in the draft, in the zero draft for this meeting that has already taken place in China, it was very important to establish the links between the different ecological challenges, the link between climate change and biodiversity loss, and the different sorts of pollution. And this was considered from the point of view of the efficiency of the different activities and actions that should be developed by the United Nations institutions, and as well from the point of view of the states' policies and actions to try to face climate change, biodiversity loss, and pollution at the national level. So, and this is maybe one of the most important issues that I would like to discuss with you, because this is one of the things that for me is the most important from the point of view of diplomats. In the case of international environmental law, the first thing that I have already said is just states are expected to incorporate in their national legal system the global goals of environmental protection. In the negotiations processes that take place in the conference of the parties, or these multilateral conferences that are prepared by the United Nations or the UNEP. And this is something that is very important from the technique of the different methods of negotiations. And I know that my approach is always maybe very academic, but I had some interesting experiences working as a consultant for the European Commission, the European Parliament, and the foreign affairs departments of ministries of some European countries, as the Netherlands, Germany, and of course Spain. So one issue that for me is always quite enlightening is the fact that environmental law is somehow has been the product or the byproduct of international environmental law. The international agreements have a seminal effect in the national system. And so this is something very important, at the same time very problematic, because when we are thinking about negotiations and at international level, when we are thinking about negotiating an international treaty, diplomats, they have to achieve a reciprocal adjustment of interest that is at the origin of this international negotiation and decision-making processes. And at the end of the day, what they are trying to do is just to defend the national interest. So it has an effect in the final treaty or in the final binding instrument that is going to be adopted. It means that the negotiators, they are going to agree about the main issues, and they are going maybe to hide, and this is something problematic, they're going to hide those aspects that could make very difficult to reach a consensus. And this is very interesting for me, because the situation that is a general problem in international negotiations and in international law in general is it has a very important impact in the case of the international environmental law, because it means that in the moment of the implementation, all the hidden interests are going to surface and are going to create problems of implementation, because the international interest is going to be undermined by the national interpretation of what are the obligations, what are the initiatives they have to take. And this is, from my point of view, maybe one of the root causes of the lack of implementation of international agreements. So national interest prevailing. But at the same time, because the assessment of the status of implementation of international environmental agreements led the United Nations and the diplomats and the negotiators to agree about something, that it would be important to try a different formula. And the first time it was introduced in the negotiations, it was in the case of the Paris Agreement to fight climate change. Instead of proposing a legal regime that will be followed by states and will be proposed from above, the negotiators in this Paris conference, they thought that the most important new approach, and it was negotiated in the pre-conferences, will be the idea that states will propose what sort of commitment they were willing to accept. And they adopted this new formula of the nationally determined contributions, voluntary nationally determined contributions, regarding what sort of obligation they were going to adopt in terms of mitigation, reduction of emissions, and adaptation to the new realities that we will have to face when these extreme weather events are going to start to change our life and to change the planet. So the formula of the Paris Agreement became maybe a test for the will of states to demonstrate that they were willing to fight against climate change. The situation is that, because we have been talking about, you have been talking and I have been listening to the other speakers. The situation is that we are at a moment that is quite interesting. Just in a few weeks, it will take place, the Conference of the Parties in Glasgow. And I'm going to be there. It's one of the experiences I am waiting with a lot of interest, because I will be representing social society, NGO. Well, I mean, I will be part of a little representation of the Barcelona University, because we were working on climate change together. And I will have the opportunity to attend this Glasgow Conference of the Parties. For me, it's quite important. You have been talking about what is going to happen next. And this is important from the point of view that we are expecting much more, because the assessment of the results that have been achieved in the past years are quite, well, disappointing, to say the least. Because just 2 years ago, the United Nations institutions, and they were expecting that the parties of the Paris Agreement, they were going to present new nationally determined contributions. The European Union did it at the end of 2019, and we were trying to show that we were going to lead in this direction of going further in our fight against climate change, leading by virtuous example. So we made a plan just to try to establish the way to lead to this new decarbonized economy, and accepting the very high cost that this new decarbonized economy will entail. But not just that, and talking in terms of diplomacy, the European Union has introduced the fight against climate change in all the agreements that we are negotiating at international level. I mean, the agreements that the European Union negotiates with third states, bilateral agreements, multilateral agreements, the free trade agreements that are becoming very, very important, just to show that when we are thinking about trade, we are introducing as well this climate change condition. We talk about the climate change conditionality that now makes part of the values of the European Union. But it doesn't mean that we are being successful when we talk about leading by virtuous example, because the situation in the case of the environment is very complex, and at the same time, it's a very interesting challenge that the European Union is trying to face. Is the idea that when we are talking about environmental problems, in order to be part of the solution, we have to be part of the problem as well. And this is something that it has been said during these days, when yesterday it was said that China and the United States of America are now the main responsibles of climate change. And this is true. I mean, the numbers are terrible, and they show that you have to be part of the problems in order to be part of a possible solution. And the situation is just China is responsible of over 25% of total emissions. The United States is responsible of over 17% of emissions. Now India is even emitting more than the European Union with a 7%. The European Union used to be responsible of a 10% of the total emissions. Now we are, the number has dropped to a 6%. So if we are just responsible of a 6% of the pollution, of the emissions that provoke the climate change, we cannot accept that we cannot be part of a possible solution. So we have to face different challenges. In fact, this is something that I wanted to share with you. In the case of the European Union, we have a special representative for foreign affairs, and his name is Josep Borrell. He wrote a book about how can we, the European Union, have a role in the global scenario, in the post-pandemic scenario. And he wrote a chapter precisely talking about how can we find our way to survive and to find our own ways in a world that seems to be reduced to the competition between the United States and China. So they call this the Sinatra doctrine, because it means that the European Union needs to find its way in the global negotiations in order to propose ways to fight climate change. So the United States of America, thanks to President Biden, the appointment of Mr. Kerry as the special representatives in subjects, issues related with climate change, has been a hope for the world, in order to think about what are the possibilities of fighting against these global problems and trying to revert the global problem. Here, this is something that it will help me to talk about this ecological challenges. If you look at it, again, sorry to say that everything was discussed in the past and that we did not react in the right way. You can see that the World Health Organization has presented a report for the Glasgow Conference of the Parties, just trying to establish the relationship between health and climate change. And the IUCN, one of these very special NGOs, specialized to provide the best science knowledge to UNEP, had already said almost a decade ago, the way that we were treating the environment, the way that we were changing the habitats will have some sort of impact in our health. So they were just mentioning that one of the main drivers of biodiversity loss and indirectly as well impacting in the climate change is the change of land use, the deforestation that are becoming one of the reasons why the viruses, the zoonoses are taking place and could be in the origin of this pandemic. So what are the reasons why that we can talk about the limits of the outcomes of the environmental international law? For me, I was just trying to give you again a different approach, and it's the idea that when we are negotiating international agreements, and diplomats, they know this, is the fact that in the case of international environmental, and I will come back to this idea later, we have to take into account different instruments depending on the intensity of the legal value of these instruments. First of all, when we think about the Framework Convention on Climate Change or the Framework Convention of biodiversity, we have to think about, we call it umbrella treaties, and they are treaties that set out the very basic principles that are going to be so general, that are going to attract the highest number of states, because with framework conventions, we are looking for a universal presence, of all the states that could be involved. But the situation is that we need to go further. So we call these international agreements pactum de contraendo, because they are going to be binding, but at the same time, they are going to ask the states to go further in their commitments. So they are going to ask states to further negotiate and further develop the legal regimes for the protection of the environment. However, and this is something that for me is also very important, this is the moment in which the national interest, the national circumstances can surface. And for example, yesterday it was mentioned that the United States of America decided not to unsign the Kyoto Protocol. They have, the United States have decided to stay aside some of these very important international agreements. For example, in the case, I was thinking about the protocols on biodiversity that have a very important link with some of the issues related with access sharing to the benefits coming from the exploitation of genetic resources. So with the framework treaties, what we achieve at least is a common understanding of what are these ecological challenges. However, the idea of how to reach higher commitments or better outcomes depends on the willingness of states to go further in the obligations that they are going to have to accept and to introduce in national regimes. For me, it was quite clarifying this environmental rule of law report that UNEP presented in 2019. It talks about precisely the increase of environmental legislation. It says that there is a 38-fold increase in the number of environmental laws. So it means that since 1972, states, they have been introducing new rules, new dispositions, standards in their national regimes. But the problem, and this is very important, is the lack of implementation and enforcement. So unless we decide implementing and enforcement rules, environmental rules and standards, and the way we have to do it, because this is something that at least I would like to mention. When we are introducing environmental law, and sorry for making such a complex problem something simple, but we have to take into account that the resources, the problems, the legal regimes are so different if we think about civil law or the Anglo-American system, and where we think about legal system in Africa or in Asia or Latin America. But what we know is that we have common goals to achieve. So in this particular case, when we talk about international agreements and then the environmental law, we are thinking about at least common standards of protections, establishing system in which states must control the way licenses and permits are given to companies and enterprises, the way they are controlling the production or the methods of production of these companies in their territories or under their control. And the idea that was also present in this environmental rule of law, that it was the idea that trying to prevent environmental damage or environmental harms is also related with establishing deterrent and proportionate and efficient sanctions against those very serious infringements of environmental law. And sorry, because maybe this is too academic and too legal, but the idea is that if we want to achieve environmental protection at the international level, we have to start at the national level. And this is something quite problematic. So, well, this is something about the European Union passage. I will focus on other things. For example, here, what you can see is the idea of démarche. So démarche is it's the diplomatic language used for these actions that are agreed by, in this particular case, the European Union member states services and the European External Action Service. So we developed quite early in 2000 this démarche in order to protect the environment. And this is something that sometimes we're quite successful, like in the case of the Paris Agreement, when we thought that the Paris Agreement had to be a binding instrument. So I was thinking about precisely what could be some of the challenges for diplomats. And for me, I will focus on two main challenges. First, and this is something that for me is important, we have some sort of deadline for the planet. Diplomats, are they ready to commit to negotiate, bearing in mind long-term issues, long-term strategies, long-term policies? Because in order to reverse climate change, we will need several centuries. So considering that politicians are always taking into account the vote and they are thinking in terms of 8 years or 4 years. And how can we protect the environment if we need to have a longer term commitment? And this is something very important, because the truth is that some diplomats have been saying that we are living now a time in which there is no appetite for multilateralism, there is no appetite for new treaties. So it means that when we cannot reach a consensus, a wide consensus, what we need, just like another formula, another solution, is soft law. Soft law is just non-binding instruments of different nature. But for me, the idea, the question I would like to present you here is that, is diplomacy any different when negotiating soft law? Because this is some of the things that for me are very, very interesting. In fact, when we think about soft law, we are thinking about non-binding instruments like this declaration adopted in Kunming this past Wednesday. And as well, like in the Paris Agreement, we are thinking about treaties, binding instruments, but having some disposition that we will call soft obligations of soft disposition. And this is a very interesting academic debate about the legal nature of these instruments. So for me, it's important because this is something that for me might be interesting for diplomats. Is the idea that if we are not going to reach the consensus required to adopt a treaty, what we are going to accept is a soft law instrument that is going to be at least enough to propose a global policy, or is going to be at least enough to propose a horizon of legal expectations in order to protect the environment. So in this past meeting of the Conference of the Parties on Biodiversity, they were talking about ecological civilization. So I think this is a very, a grand word, a grand title. So could you please pass the slide? So, well, sorry, it's just, so sorry for being a little bit, I have had a problem with the PowerPoint. I'm very grateful to you for your help, but at the end, the order is a little bit different. But nonetheless, this week, has been a very special week, and I think it's just, for me, it has been a privilege to share with you the things that are very important to me. So the last Friday, the United Nations Human Rights Council adopted this resolution with the favorable vote of many states, the United States of America, one of them, about a right to a clean, healthy, and sustainable environment. So thinking about soft law instruments, this one is one of them. There was some abstentions, but no negative vote. And this is important because these resolutions adopted by the United Nations Human Rights Council, or the resolutions of the General Assembly, they are triggering legal processes, decision-making processes. They are triggering the next constitutionary processes, but at the same time, they could be maybe the first stage of a new treaty. In this particular case, it's almost for sure that it will take a long time to get there. And this is something that for me is also very interesting, just to say that some years ago, a think tank, a French think tank, Le Club de Juristes, they presented this project, a project for the recognition of the human right to the environment as a third generation of human rights, and as well a global pact for the environment that would be capable of codifying together the main principles regarding the environment. This project, made by an NGO, was endorsed by France, that brought the project before the General Assembly of the United Nations to one of these site meetings during the month of September, and it was discussed by the General Assembly, and at some point they were considering the adoption, the human right to the environment, and they were considering the adoption of a global compact, a global pact on the environment that will be able to, to put together something that is perceived as a fragmented legal system. But at the end, the French proposal, even though the diplomats of the European Union were at the service of this French proposal, failed. So they decided to commemorate the 50th anniversary of the Stockholm Declaration with a resolution that will take into account these different proposals. So we can see the power of self-law, the power of the idea of making a horizon with the legal expectations related with not just the interpretation of environmental agreements, but as well, establishing firm ground for the new treaties of the future. Not just human right for the environment. Not just a human right to a healthy environment. Not just thinking about rights for the humans. This is something that is also becoming very, very important. The idea of attributing rights to nature, something that have already taking place in countries like Ecuador, Bolivia, and as well municipalities. And the Council of Europe has also made reports on that. And Pope Francis talk about a true right of the environment before the General Assembly. And this is something that I thought it was important to share, because this is one of these ideas of non-binding instrument declarations that are made before the General Assembly that can have a seminal effect in the future. In this particular case, is the idea of the Kunming Declaration talking about ecological civilization. And just to finish, well, this is the idea of the global compact that I mentioned that was proposed by the Club des Juristes in France. And this is the point I want to finish with. And the idea is, if you have followed the international conferences that have taken place and the meetings, the summits that have, for example, the summit that President Biden led in last month of May, states, international organizations are making environmental pledges. They are promising that they are going to take into account the environment, that they are going to protect the environment. And in this particular case, I wanted you to think about the possibility of proposing and accepting a pledge for diplomats, to think about a green diplomat pledge or a climate diplomat pledge, in order to introduce in the diplomatic agenda the fight against climate change as one of the priorities for diplomats now and in the future. The way they should develop these démarches, these actions to protect the environment and to adopt measures to fight it efficiently in Conference of the Parties. And this is it. I wanted to propose to you, will you be able to accept a pledge to protect the environment as a diplomat? What would be the obligations that you will accept in your condition as a diplomat if you are asked to protect the environment? And that's all. And thank you very much for your attention.
Teresa, I want to thank you for a remarkable lecture, and you've touched on so many important topics: the importance of multilateralism, the challenge of nations protecting their own sovereignty, and then the actions that we must be willing to take, both as practitioners of diplomacy and as citizens. And so I thank you so much for this wonderful keynote. Teresa Fajardo, thank you to you, and thank you for coming to us from Granada, Spain today.
My pleasure. Thank you very much.
All right. Our next session on Indigenous voices in environmental diplomacy will begin at the top of the hour, and that is in 3 minutes. So a brief break, and we'll be right back to you. Thank you so much.